us what is the Bulgarian situation. And in particular, you will speak us about the construction of the system of remedies. Please, Krassimir.
Good morning. My focus will be on the role of the European Court of Human Rights on the prison reform in Bulgaria. But I would, of course, like to say a couple of words in the beginning about the background of the Bulgarian prison system, and also about the role of our organization. Our organization is the Bulgarian Helsinki Committee. This is a human rights non-governmental organization. We have as in Romania, a free access to the Bulgarian prisons, mostly for the purposes of human rights monitoring in the prisons, but also to offer prisoners legal assistance. This is how we pick actually most of these cases that we have brought to the European Court of Human Rights, and there have been many since we started our work in the prisons back in 1994. We were issued passes on a yearly basis by the Ministry of Justice, and with these we present them to the prison authorities and go directly in the prisons, including in the cells of the prisoners, where we can interview prisoners. Now, on the background of the prison conditions, there are now around 7,500 prisoners in Bulgaria, accommodated in 13 prisons. 13 prisons we have formally, but each one of these prisons has the so-called prison hostels, open or closed prison hostels. And some of these prison hostels are prisons that are not distinguishable from the main prison buildings. So altogether we have 32 separate prisons. Some of them are very small, accommodating somewhere between 20 to 30 prisoners, and some of them are quite big. As in the case of Sofia Central prison which accommodates up to 1,000 prisoners, so they differ in number. Overall, the material conditions of detention in the Bulgarian prisons are quite poor. Now, all these buildings are very old. They have been built 50, 60, some of them 100 years ago. We haven't had new prisons constructed after 1989. I myself go very often to monitor prisons in countries outside of Bulgaria, and particularly in the Middle East. Recently I have been on several missions in Jordan. There I found that their oldest prison is from 1989, the oldest prison in Jordan. Our oldest prison is from 1908. So overall, as I said, very bad conditions. The good thing is that the number of prisoners decrease on a year-by-year basis. We used to have 9,000, sometimes 10,000 prisoners to a population of around 7.5 million. Back in the communist time, we had in the mid-80s 17,000 prisoners for the same prison conditions. But having said that the number of prisoners is decreasing, we have to say that this is a general trend vis-a-vis the numbers, but not necessarily vis-a-vis the shares of population, because the Bulgarian population is decreasing. And particularly the population in the age group between 20 and 40 years of age, which is, I mean, 80% of the prisoners in Bulgaria in this age group, there's no decrease. On the contrary, there's an increase, because we had a lot of these age group emigrated. We have very negative birth rate figures. Okay, so going now to the European Court of Human Rights, the identification of the problems of the Bulgarian prison system, and the assessment of the remedies. First, a little bit about the scope of the problems identified by the court in its judgments against Bulgaria. And they were many, and they were diverse. And they were quite diverse in terms of problems. The major issue has been in almost every case that the European Court of Human Rights heard about the prison's material conditions of detention, including overcrowding, hygiene, access to outdoor exercise, food, access to medical care, these parameters of the conditions of detention. Then another issue has been the lack of effective remedies for violations of Article 3 related to material conditions. I will talk about this in more detail when I talk about the Neshkov judgment, the pilot judgment. Special regime and other types of isolation. The Committee of Ministers views this issue as an Article 3 issue, and because it is it creates a special regime, and isolation creates inhuman and degrading conditions. But it creates inhuman and degrading conditions by itself. I will view it a little bit separately from the issue of the material conditions of detention, because in the recent judgments, and particularly in the Harakchiev and Turumov judgment, of which I'm going to speak later, the court paid a specific attention to this issue and distinguished it from the issue of material conditions of detention. Then we have the whole life imprisonment, a very important issue identified in several judgments against Bulgaria. Physical restraint of prisoners with mental disorders in the recent judgment of Timov v. Bulgaria, surveillance of prisoners' communications, as well as disciplinary measures. Those three latter issues, the physical restraint, surveillance of prisoners' communications, and the disciplinary measures, I'm not going to talk about because I have no time. I will focus on the other issues and on the effect of these judgments on the Bulgarian system. I'll talk about the recent reform efforts of the Bulgarian government focused on these problems. The surveillance of prisoners' correspondence communications was an issue that was somewhat surprising to me. Closed by the Committee of Ministers. They do not consider this issue anymore a problem for the Bulgarian prisons, although it continues and it brings also cases to the court, same as the disciplinary measures. This group of judgment was closed, declared executed, but the problem continues, and there's another group of cases brought to the attention of the court. In addition to these problems, we have to mention also those that have been identified by the European Committee for the Prevention of Torture in March last year. The European Committee issued a public statement against Bulgaria, a very harsh public statement, the seventh in the history of the CPT, in which it identified some of these problems, particularly the issues related to the material conditions and isolation of the prisoners. But added to these also other issues, the ill treatment of prisoners by the staff, the inter-prisoner violence, and the situation in the investigation detention facilities. These are the pre-trial jails. We have 34 such pre-trial jails. Those are former police detention facilities, and they are not suited for accommodation of prisoners for long periods of time. And the conditions there tend to be much worse, even compared to the prisons. But so far, we haven't had a pilot judgment related to the situation in the investigation detention facilities. Okay, now about the pilot judgment, the Neshkov judgment, and this is a judgment that was delivered by the court last year in January. It came as one in the series of judgments of the so-called Kehayov group of judgments that is pending for execution by the Committee of Ministers. And they are all related on the issues of material conditions of detention. This is overcrowding in the Neshkov judgment. The Neshkov judgment was a judgment of Mr. Neshkov plus 5 other prisoners who have been accommodated in different prisons of Bulgaria, spent considerable time in those prisons, and it reflects very well the overall situation in the prison system, because it brings facts from different prisons. The court in Neshkov identified that the applicants were accommodated in cells with between 1 square meter and 4 square meters overall space per person, rarely more than 4 square meters. Lack of separated toilets in some cases, in most cases actually, and in some cases use of buckets at night. Lack of ventilation, including metal shields on the windows in some prisons. Bad hygiene in the cells, in the kitchen, and in the common toilets, the access to which is difficult due to the overcrowding. Lack of separation between smokers and non-smokers. Poor quality of food, poor access to medical care and medicines. Lack of activities. In essence, those prisoners were accommodated in wings where they would spend 22 to 23 hours a day with just 1 or 2 hours outdoor exercise. And that would be all for the day. Almost complete lack of activities. Activities in the Bulgarian prisons were mostly work. And the number of prisoners who offered work decreased substantially over the past 20 years. Almost 95% of the prisoners in 1989 were working. Now it's not more than 15%. And share is decreasing. Okay, so this is what...
Sorry, which kind of work they are doing?
Well, they were, as in all communist countries, prisons were related to major enterprises. We had, for example, a huge metal enterprise and there will plant, and there will be a prison nearby, as in Russia. And other.
And they are paid by the enterprise?
And they are paid, yes.
By the enterprise or by the state?
By the state. Well, at that time, it wouldn't matter. It was both enterprise.
Yeah, it's a state enterprise. Okay.
And the prison was in the state hands. But now they are paid by the enterprise when they are offered work, if they are. And the same with every other.
And the salary is the same for the other?
No, it's not. It's the minimum salary, and 2/3 of the salary is paid for them. So it's very minimum. But they have a huge benefit from working because 2 days of working is considered by law as 3 days of imprisonment. So they would be willing to work even without being paid, which is the case in many with many prisoners.
But just a question, because this is a problem around Europe, which is quite interesting. For instance, we have a discussion of this kind in Italy. But if, I mean, working people have a discount, let me say, in the amount of time that they have to spend in prison. If you cannot accept all the ones that want to work, it's not a kind of discrimination.
Yes, of course.
And on which base it can be justified?
On no basis.
On no basis.
Well, but this has been the case since 1922 in Bulgaria. It's not a...
But you never go in front of the court on this kind of... Neither national court?
No.
No.
Well, it's also a huge source of corruption. Yeah, if you have such a huge benefit, of course, you're tempted to, to receive bribes from prisoners and from their relatives to assign them work. Okay, so these conditions of detention, the European Court of Human Rights in this pilot judgment viewed as inhuman and degrading, and stated that the government should take urgent measures to improve them, although it didn't set a time limit for the improvement. It's difficult to do this for the material conditions of detention. It did so, however, with the other aspect of the pilot judgment, which is the effective remedy under Article 13+3. Historically, we had 2 types of remedies in Bulgaria. One compensatory remedy and another preventive remedy. The compensatory remedy was a possibility for action for damages under the State and Municipalities Responsibility for Damage Act. And it has been considered by the court in many judgments, including in the pilot judgment. In theory, in principle, as the court says, to be an effective domestic remedy. But it is not sufficiently effective due to the following reasons. One is that the courts do not explain the claimants what they must prove. Second, the courts impose excessive burden of proof on the claimants when they claim damages. The courts apply the norms of the national law, said the court in Neshkov, in an excessively formalistic way. Do not apply directly the convention standards and do not take into account the cumulative effect of different factors. In other words, it would split the case into smaller cases and would require proofs for damages in each detail of the overall situation, without taking into account the cumulative effect of the different factors. There is no presumption of non-pecuniary damage. In many cases, the courts would ask the claimant to prove that he or she had actually suffered. How do you prove that you have actually suffered when you have put in inhuman and degrading conditions? The big question mark. In some cases, the courts would require medical evidence as a proof for suffering. And the courts do not take into account the conditions, the continuation of the situation. It would be a claim for a particular situation, limited to a particular time frame. I mean, you may have suffered 10 years ago in the same conditions. The court would restrict its adjudication to the facts of the specific case without taking into account the continuation of the situation. So, for this reason, the court in Neshkov said that this compensatory remedy is not effective. With regard to the preventive remedy, we have a possibility to direct, for the prisoners, to direct requests to the administrative courts, demanding action on the part of the prison administration or termination of actions. This is provided for under the Administrative Procedure Code. But this is these requests, according to the court, have been ineffective. Ineffective because they have never worked. Not in one case. Only in one case, I think, which the Neshkov reported. Then we have also, in terms of preventive remedy, the possibility for transfer in other prisons, which is given in practice. But it's limited due to the legal limitations of the regime. That according to the law, if you are under a certain regime, if you are a recidivist sentenced to a long term of imprisonment, you are only allowed to be accommodated in a specific institution. You cannot go to another facility. Another facility may be empty, but you cannot be transferred there because your regime requires that you are accommodated in that prison. And also because there's a general overcrowding in the entire system. We have also this possibility for complaints to the prosecutor, and the prosecutor may take action, but this is an action entirely at the discretion of the prosecutor, and there's no participation of the interested party of the claimant in this case, and for this reason the court considered also that remedy to be ineffective. Okay, in Neshkov, as well as in several other judgments, but more specifically in Kanev, the court came up with criteria of what constitutes, what are the requirements to the preventive and to the compensatory remedy so that they can be effective. And this is with regard to the preventive remedy that the authority granting remedies should be independent of the authorities in charge of the penitentiary system, that the inmate should be able to effectively participate in the examination of their grievances, that the mechanism must ensure the speedy and diligent handling of the inmates' complaints. The competent authority should have at its disposal a wide range of legal tools for eradicating the problems that underline these complaints. The competent authority should be capable of rendering binding and enforceable decisions. Those are the requirements for the preventive remedy. With regard to the compensatory remedy, the burden of proof imposed on the claimant should not be excessive. The judicial proceedings must be in compliance with Article 6, Paragraph 1 of the Convention. The litigation cost should not be excessive, and they used to be in our case in the past. claimants should not be asked to prove unlawful acts of specific officials, but they should rather concentrate on situations. It should be possible to examine whether the interferences in the rights of the claimant had been necessary for the achievement of the legitimate aim. The court must be able to review the complaint in the light of the convention standards, including with regard to the level of compensation. This is a particularly serious issue because in our cases where the claimants have been successful, they would obtain 50, 100, 200 euros for being placed in inhuman and degrading conditions, sometimes for 3 or 4 years, 5 years. And finding of a violation should give rise to a strong presumption that it has caused non-pecuniary damage to the aggrieved person. So there's no burden of proof should be, in this sense, alleviated. So those are the criteria for the preventive and for the compensatory remedy. Now, a little bit about the Hartiev and Toulouse judgment dealing with the special regime and other types of isolation. I'm talking about special regime and other types of isolation because very often these are different issues. Special regime may be the regime of imprisonment, it may be the initial regime, it may be a regime that was subsequently determined or imposed on the prisoner. It may be a regime as a result of certain action to isolate this prisoner because of specific acts that he had, or because of the specific problems that he had posed. Or it may be a regime of isolation because for the purposes of punishment. In Hartiev and Toulouse, the court established that the material conditions in which both prisoners, and both were life prisoners, were bad, very poor, but they were for the court of a secondary importance. Isolation and lack of communication with other prisoners for 22 hours daily were the major issue in this particular case. And this is what ultimately constituted for the court inhuman and degrading treatment in violation of Article 3. There were no activities, very few visits, and both prisoners were placed in such conditions for a long period, for long periods of time, 12 to 14 years. And here the court said that the isolation should be justified by particular security reasons obtaining through the duration of this measure. So there should be no regime of isolation that is inhuman and degrading. Security measures in this form should be justified by particular security considerations throughout the duration of the measure. The other issue identified by the court in Bulgarian cases was the whole life imprisonment. We had plenty of cases related to the whole life imprisonment. We have the whole life imprisonment under the law. And, well, the standards that the court established in this regard was somewhat of a moving target. Back in 2010, with the Yorgov number 2 case, the court said that presidential clemency in Bulgaria is, before 2012, had no criteria. Well, the president just could reduce the sentence of a prisoner or free him as he wishes. And this is also here. And according to the court, this was an effective tool which makes the whole life sentence reducible. And therefore, there's no whole life sentence in Bulgaria in this Your Group judgment of 2010. The approach of the court, however, changed, particularly with regard to the reform of 2012. In 2012, our Constitutional Court considered presidential clemency, and it required that the president should come up with some criteria on the basis of which he should operate when granting clemency. Those criteria were several, but the major one was to what extent the prisoner was able to improve in the course of his or her imprisonment, sentence. And this is interesting now. In Réseau and Toulon, one of them, Réseau, was a life prisoner. He had a whole life sentence. The court said that the presidential clemency, even after the reform of 2012, as a result of which the president came up with some criteria, was not an effective tool which makes the whole life sentence reducible due to the restrictions of the regime. The restrictions of the regime being the impossibility of the prisoner to meet this criteria. His regime is such, the court said, that he cannot meet these criteria. In other words, it's not enough just to have these criteria, whether they are in the procedure of clemency or in some other procedure. You have to offer the prisoner also a possibility through his behavior while in the prison to meet these criteria. And with this strict regime of isolation, it has not been possible for the prisoner to meet, and therefore, even though we had these criteria, the court found that there had been a violation of Article 3. And this was confirmed in a subsequent judgment of Mano of Bulgaria. The court said basically the same in similar circumstances. Okay, now I come to the draft legislative amendments after the pilot judgment. And I will distinguish, so after the pilot judgment, the Ministry of Justice formed a working group. It invited non-governmental organizations, academia, persons from the judiciary, from the prosecutor's office, to draft legislation in response to the Leshkov judgment. As of now, this legislation is not final, although it is published on the website of the Ministry of Justice. But yesterday, our Deputy Minister of Justice surprisingly said that this is not the final version of the legislation. We don't know what is it going to be. I'm going to deal with the published draft law. Okay, with regard to material conditions, the law will introduce 5 square meters space per prisoner, although a bit below the CPT standard, because it talks about the overall space per prisoner, 5 square meters. The CPT, in its standards, talks about 5 square meters, excluding the separated toilet. Our law says 5 square meters overall space, which normally would include the toilet. So far, we have this, in fact, in the law, but its implementation was postponed for January 2019. Now it is going to enter into force immediately. The law envisages, the draft law rather, envisages several measures related to allocation. The prison administration is given power to use overcrowding as a criterion for allocating prisoners. So far, they would allocate the prisoner on the basis of his or her place of residence to the nearest prison, as the law says. Now, they are going to consider also whether the local prison is overcrowded, and if it is, they would be allowed to move him or her to another prison. The prison administration is granted more operative powers to use the open type prison hostels. In other words, the criteria on who is entitled to be moved to these open type prison hostels were changed, and the prison director is given certain discretion to move prisoners from closed type to open type prison hostels. Directors were also given powers to transfer prisoners to other prisons with their consent on a more flexible basis. So if the prisoner says, this is an overcrowded prison, I live nearby, but I want to go to another one because I can't stand it here, with his consent or her consent, he or she can be moved to another prison. And there's also a possibility for judicial review of the director's actions on the motion by the prisoner. The legal framework for early conditional release was changed. Each prisoner's case will be automatically now brought to the court once certain time of serving of the sentence has passed. So far, this has been possible only when the director decides, or there was a commission inside the prison that decided on this. So it was upon discretion. The major criterion being whether the prisoner had improved while serving his or her sentence. Now, when the time comes, they would automatically go to a judge. More flexibility was granted for the reduction of the special regime by the prison director, including periodic 6-month review of the special regime, with a possibility for judicial control of the director's decisions. So this is regarding the substantive aspect of Article 3 to accommodate the concerns of the court in that regard. With regard to the remedies, the draft law envisages, with regard to the compensatory remedy, first of all, defining what inhuman and degrading treatment is in the execution of punishment in the Pre-Trial Detention Act. And this is a very broad definition. Introduction of a special procedure for damages as a result for poor material conditions to administrative court and the state and municipalities' responsibility for damages tax. Shifting the burden of proof to the prison administration once a prima facie case is submitted to the administrative court. And also the draft law says that the amount of remedies should be should take into consideration the cumulative effects of the exposure to the inhuman and degrading treatment, and also it should be possible to apply the convention standards in that regard directly in the domestic courts. On the preventive remedy,
sorry, Krassimir, just because it's something that maybe if it's possible that this afternoon I would like to discuss with you, Raymond. But when your definition, the possible definition of inhuman degrading treatment, is in a certain way connected to the evolution of the jurisprudence of the court or not?
Yes, very much.
It's open in a certain way.
Well, so we had such a definition so far in that law as well as in other laws, but it concerns intentional acts only, whatever time. Now it's the situation. Yeah. And the court is allowed to, it's not allowed, it is, it has to apply the convention standard directly.
It has
if the lawyer...
He said that it has to apply the convention standard as defined by the European Court.
Yes, as defined as defined by the European Court of Human Rights. In other words, if the lawyer says in that judgment, it's similar situation, we had certain material conditions similar to my material conditions in this case, and the court said that this is inhuman and degrading treatment and awarded certain amount of money. The court would be asked and would be compelled to award the same amount and to, of course, assess those conditions in a similar way.
Then it is an open law. I mean, the definition is open.
The definition is open, yes.
Okay.
Well, if it remains...
in a certain sense, it's up to the European Court to define...
Indeed, yes. But if it remains as it is in the current draft, as I said, so fine. We will see what happens. And with regard to the preventive remedy, there's a special procedure also in the Execution of Punishments and Pretrial Detention Act, where the prisoner may turn to a judge to demand, to request for termination of action or a situation, for instance, the judge may, in this case, order action to the prison authorities, like, for example, removal of the prisoner to another prison, or placing him in another type of facility in the same prison, depending on the situation. Okay.
And there is a time there is a time limit, yes. How long is it?
Well, it depends on the court must set a time limit for...
No, but for the court to take the decision, there is a time limit or not?
That I don't remember. But maybe the court will hear the case. There may be a time, but I don't remember it now. Okay. So this is the scope of the remedies as they are now in this draft law. And I would finally say, so just very briefly, a couple of words about the outstanding issues. So far I have talked about the material conditions of detention, isolations, effective remedies, but there are some issues that have not been dealt with or have been dealt with by the European Court of Human Rights, but are still outstanding. They will be outstanding even if this law enters into force. As I said, surveillance of the correspondence is one such issue. This continues, although this group of cases was closed by the Committee of Ministers. So is the disciplinary punishment as an issue. Closed cases, but punishments continue. Whole life sentences, the issue is not resolved, and that law will not resolve it. There are issues that have not been dealt with at all so far by the court. The right to vote, for example, we have a pending case before the European Court of Human Rights, Kolinsky and Sabov, and we are expecting a judgment this year. And the right to vote is a difficult issue in Bulgaria because it's provided the prohibition of the sentenced prisoners, the prisoners serving effective prison sentences to vote, is provided for by the Constitution. So we have to change the Constitution. It's very difficult to change the Constitution. Then the international transfer of prisoners, a very interesting issue, of which there's very little jurisprudence so far by the court. This is in the case of Paul Freeman v. Bulgaria. Also a case pending before the court, also we're expecting a judgment this year. And interprisoner violence, this issue that has been identified by the CPT, by the European Committee for the Prevention of Torture. We have not had serious cases so far. There's one pending before the court, which is awaiting a judgment, maybe this year, maybe next year. This is the Jaume 2 case. Okay, well, that was all I have to say. Sorry for exceeding my time, but you were interrupting.
Yeah, it's my fault. It's just my fault.